Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a criminal case. The criminal case is a misdemeanor case. You will be examined for inclusion on this criminal jury, and our courtroom varies normally from 8 o'clock, from 8 o'clock in the morning to 5 in the afternoon. Now, in this court, we have large dockets, so the dockets are where we have a lot of cases, and we hear our cases in the morning. So therefore, our jury trials will be from 1:30 until, it could be 1:30 to 5, most of the times. Now, if the case is in its final stage, that is, the jury is deliberating, we can't go beyond 5 o'clock until the jury reach a verdict. If not, then we can recess until the next day. Now, your inclusion on this jury is a right that only free people can perform. If selected as a jury in this case, the case will be tried expeditiously consistent with justice, which require a careful and impartial and a correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate for recess, for lunch, and at night. At this time, I have an administrative matter that I must attend to. So at this time, we need everyone on the panel to raise your right hand as I administer this oath to you. And then once I finish administering the oath, please say, "I do." You and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a juror, so help you God. Okay, you may put your hands down. Now, ladies and gentlemen, the law requires that each of you possess certain qualifications before you may be considered as a member of a jury. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on the jury, this case can be retried, and you may be held in contempt of court, placed in the Jefferson County Jail for up to 180 days, and given a fine up to $500. Now, I will first determine whether or not you're qualified. And the way that I'm going to do it, I will ask a series of questions. I do not want you to answer the question out loud. Once I finish asking the last questions, I then will ask you, is anyone disqualified under the law? If you think that you may be disqualified under the law, then you will simply raise your right hand, and then we will ask you to come up before the bench outside the presence of the other jurors. And when I mean outside the presence of the jurors, what I mean by that is, we on YouTube, we'll turn off the YouTube channel, or we'll put it on mute, and then we'll turn off this mic, and then we'll put on our noise device. And then once those things are done, then we will ask you some questions to determine whether or not you are disqualified under the law. So again, I'm going to ask a series of questions. Once I finish the last questions, I'll ask if there's anybody who feel that they may be disqualified under the law. So the first question is as follows. Except for failure to register as a qualified voter in Jefferson County and the state of Texas, under the Constitution and laws of Texas, the second question says, have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause and explain that I have to ask this question by law. I'm not trying to meddle into your personal affairs. I'm just trying to ask the question that we are required as judges to ask for a criminal case. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is there anyone here who, after answering the questions to yourself, you feel as though you may be disqualified under the law? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel have raised their right hand. So at this time, all the members of the panel are qualified. Now I will proceed to exemptions, and I will handle the exemptions in the same manner that I handled the qualifications. That is, I will ask you a series of questions. Please answer those questions to yourself. And then once I finish with the last question, I'll ask if there's anybody here who would like to exercise an exemption. And if you would like to exercise an exemption, you may raise your right hand. Now, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim any of them. First question, are you over 70 years or 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and any jury service would necessitate leaving a child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the state, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in this county during the 3-year period prior to today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States Military Forces serving on active duty and deployed to a location away from Jefferson County? Is there anyone here who would like to claim one of the exemptions? If you'd like to claim an exemption, please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. And now with the excuses, if any of you feel as though there is a reason that you would like to claim an excuse, then once I tell you what you can claim as an excuse, then you can raise your right hand and we'll have you to come before the bench. Now, I'm not going to ask a series of questions. I will make 3 statements. And the first statement is this: a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for any economic reason without the consent of the parties. That is, you cannot be excused unless the defense and the state consents. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here who would like to claim an excuse? Let the record reflect that no one on the jury is claiming an excuse. So at this time, all the jurors on the panel are qualified at this time. Ladies and gentlemen, the case that we have before us is titled "The State of Texas versus Kenneth W. Baptiste." The time now is 2:00 p.m. on today's date of October 21st of 2024. The defendant, counsel for the defendant, counsel for the state, and all members of the jury panel are here and they are present. Ladies and gentlemen of the jury, you have been summoned to this court as a prospective juror in a criminal case. The defendant, Mr. Kenneth W. Baptiste, he's present with his attorney, Attorney William Marcus Wilkerson. The state is represented by Assistant Criminal District Attorneys, Attorney Kyle Gasper and Attorney Andrew Hubel. Yeah. Our court reporters in this case is Miss Ada Christie, and she will be taking down everything that is being said. She's to my left, so please speak up when you're asked questions or when you are asking questions. Today we have two bailiffs that are here with us. We have Miss Sharon Williams, who she's in the back. And we have Mr. Ibarra. He's right here near the bench. Now, the defendant in this case stands charged by information. And the reason why I say information, in a felony case, we call it an indictment. In a misdemeanor case, we call it an information. So the defendant stands charged by information with the offense with the Class A misdemeanor offense of resisting arrest, search, transportation. Now, the punishment range for a person who is convicted of this offense, because it is a Class A misdemeanor, the punishment range is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or a person can be given both such fine and confinement. And if a person is eligible for probation, they can be given probation in this case. The state and the defendant, through their attorneys, have the right to direct questions to you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular matter. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may be able to discuss the matter more privately. Ms. Gasper, is the state ready?
State is ready, Your Honor.
And Mr. Wilkerson, is the defense ready?
Defense is ready, Your Honor.
The panel is yours, Ms. Gasper, and you'll have 30 minutes for Radar. If you need more time, just let me know, and I'll give you the time that you need. And I will be keeping the time. You may proceed.
Good afternoon, everybody. Sorry. My name is Kyle Gasper. I'm here with my co-counsel, Andrew Duval, and today we're representing. Now, as Judge has told you briefly, y'all are here, and we are here to make this election. Because if you are not picked for this trial, it doesn't mean that we don't want you, it just means that you're not the right fit. I like to think of Radar a little bit speed dating. I'm gonna ask you a bunch of questions. Some of them might pertain to the case, some of them are just me trying to get to know you a little bit better. And I ask that you answer. I'd like to have a free flowing conversation, so then if there's anything that I can clarify or answer for you, please feel free to raise your hand. I'm gonna start out with you. Who's excited to be here? Anybody? There we go, we have one hand in the back. All right, I'm gonna need to see a show of hands for this. Has anyone ever served on a jury before? All right, we have quite a few. Mr. Keys, what type of jury did you serve on?
Same as this.
A criminal jury?
Mhm.
And did y'all read the verdict?
Yeah.
All right, thank you so much. I saw a few other hands. We have Mr. Juria? Is that how you say that?
Yes.
What type of jury did you serve on?
Civil trial.
And did y'all reach a verdict?
Yes.
All right, thank you. Who else? I know I saw some more over here. Is that Mrs. Berry? Yes. What type of jury did you serve?
I did both civil and criminal.
And did you reach a verdict in those cases?
Yes, two of them, yes, one of them, no.
Okay. You've had lots of experience. This is not your first rodeo. All right. Saw a few more hands. Yes, Mr. Shows? Shows, sorry.
Everybody does.
I understand. What type of jury did you serve?
Criminal.
Criminal? Did y'all reach a verdict in that case? Thank you. Anyone else I'm missing in the back row? Mr. Miles, what type of jury did you serve on?
One civil,
And did y'all reach a verdict?
two of the friends,
All right, thank you so much. Anybody else? I'm gonna get to everyone today, so don't be shy.
Oh, and yes.
All right, thank you. You did my job for me. All right. Now, before we get into a little bit more of the facts, do you know anybody here? Do you know myself? Do you know the other prosecutors? Do you know anyone on the defense side? Anyone know anybody here? Yes, how do you know someone here?
No judge,
And how do you know the judge?
just, showing up at different events, keep an acquaintance.
Okay, so that wouldn't affect your ability to be fair and impartial in this case, should you be picked? All right, thank you so much for telling me that. Now, my job as the prosecutor, I'm sure many of y'all have seen some sort of true crime, some sort of lawyer show on TV. There's lots of those that are popular right now. I have to tell y'all, this is not as glamorous as it is on TV shows, but it is pretty fun. I'm not representing anyone sitting behind these tables. I represent the state of Texas, and I represent this county. Now, my job is to prove to you that a crime has been committed and give you the power to make the decision. Now, who has heard the phrase innocent unless proven guilty? Anybody heard that phrase? Good, we have lots of people. Now, my job is to prove that the defendant has committed the crime, and I will do that by proving the burden of proof. Now, the burden of proof in this case is guilty beyond a reasonable doubt. Does anybody know what that means? Beyond a reasonable doubt? Yes, Mr. Oakley? Oh, Scott, sorry.
That's okay.
Mr. Scott, what do you think beyond a reasonable doubt means?
That there's no suspicion that there's validity. And it's that.
Like, thank you. Now, beyond a reasonable doubt is not a definition that I can give you. It is up to you as the jurors to come up with that definition, and that's a great start. It is up to you as you listen to this case to come up with your version of what it means to be beyond a reasonable doubt. And me as the prosecutor, that's what I'm going to prove to you. I'm going to prove to you beyond a reasonable doubt that this crime is occurred. Now, I talked about the burden of proof. Burden of proof remains with the state. It never shifts to the defendant. They don't have to prove anything because they're innocent unless they're proven guilty. Now, that means he does not have to do anything. They can sit here. They don't have to call any witnesses. They can rest as soon as we are done, and they have done all that they need to do because they don't have the burden. We have the burden as the state. Does that make sense to everyone? Can everyone understand that? All right, thank you all. So once again, I'm hammering this in because this is our job. This is what we're here to do, is to meet our burden of proof. So what we go to school for, that's what we learn in this office, and that's what we will be doing in the next few days. So it's up to me to prove the elements and to prove those beyond a reasonable doubt. We're gonna get to the elements in just a second, just laying the groundwork here, trying to get to know y'all, everyone. Is everyone following me so far? Any questions? Awesome. Now, to find someone guilty, do you feel the need to see that crime be committed? Do you feel the need to actually visually see what happened?
Would help.
Mr. Peace, it would help. I agree with that. However, if you were to see this crime be committed, you wouldn't be sitting back there, you'd be sitting up there. You'd be telling us what happened, right? You'd be a witness in this case. So we can't have everybody be witnesses, but as a jury, your job is to take the evidence, understand what everyone is telling you, and come up with that decision without being there to presently witness the crime. Does that make sense? Now, on a scale of 1 to 5, if you were to encounter a police officer in any sort of capacity, could be pulled over, run into them on the street, at the grocery store, anything like that. On a scale of 1 to 5, how likely are you to respect the authority of that police officer? Let's see some hands. 1, you're not going to respect what they're saying, and 5, you're going to do anything that they tell you as their police officer. I'm seeing lots of fives. Five,
Yeah.
yes,
You're gonna respect them, but you have to also make sure that they're being clear, concise in the direction that they're giving you, and they're not telling you anything that's gonna mislead you into doing something that's wrong.
yes, absolutely, I agree with that. And going off of that, do you think that the situation that you encounter with police officer, whether it be them acting in their official capacity or just seeing them next to you at a restaurant, do you think that that changes how you're going to react to what they say to you?
It shouldn't, but like I say, everything is case by case basis, because somebody, when they're not in their official capacity, you may not even realize that they are officers.
Absolutely.
But that's why I say, but if an officer gives a direct order and they're being clear and concise and not like giving you an order, you should obey or stop and try to see what's going on, or be like, hold up, let me just stop, let's clear this up.
Yes, communication is key, absolutely. And I agree that it depends on the circumstances, it depends on if they're in uniform, if you can tell that it's a police officer, or it might just be someone on the street. And they are an officer, but I mean, you can't tell what people do for their jobs if they're not dressed in uniform for that job. I mean, I go running on the weekends, I don't look like a prosecutor when I'm out running, but that's still my job, and that's what we're here to do today. So judges mentioned it earlier that we're here for a resisting arrest case. In your idea, before we get into any of the elements that I'm gonna have to prove, does anyone have an idea of what resisting arrest means? Ms. Broussard?
Resisting arrest means if the officer tell you to do something, you don't do it, or if he's trying to put the cuffs on and then you try to fight him or get out of it.
Do you
It's
want-
resisting.
Do you wanna come do the rest of my presentation? That was awesome. Thank you. Did everyone hear that okay? All right. So the Texas Penal Code is what gives us our crimes, and it gives us the elements that we as the prosecutor have. So under Texas Penal Code, section 38.03A, resisting arrest is when a person intentionally prevents or obstructs a person he knows is a peace officer or a person acting in a peace officer's presence, and that is directed, from effecting arrest, search, or transportation of the actor or another by using force against the peace officer or another. Does that make sense to everybody? All right, you nailed it. Like I said, you did it in a more concise way too, but we have to lay out the code in order to prove our burden, which is to meet you. Now, we're gonna break down some of these. Can everyone see the screen okay?
Not really.
No? Excuse me. Can y'all see that one?
Not really.
Not really? Okay. I apologize about that. Should have tested that out before I got up here. Well, even if you can't, we're gonna break it down and I'm going to walk you through this. So the first element is the person commits an offense if he intentionally. What does it mean to be intentional? You look like you wanna say something.
To purposely do it,
Commissioner?
to purposely do it, intentional.
Yes. I like that. All right. Moving on, what does it mean to prevent or obstruct?
To prevent them.
Yeah.
And does it matter how, or is there a lot of different ways you can prevent or obstruct something? Interfere, I like that.
Ms. Gasper, would it help if he turned the lights down?
Does that help you? You turn the lights down? Or is it just the front side?
Oh, it's the size of the phone? No, okay.
I apologize. All right, so preventing, you said interfering, I like that. Thank you for reminding me. All right. What does it mean to, in effect, an arrest? Do we know what effective arrest means? As a lawyer, we have fancy words for saying things that aren't that fancy. Effecting arrest means essentially placing someone. Does that make sense to everybody? And finally, can someone give me an example of what it constitutes using force? What is that? When you think of using force, what do you think of?
To prevent somebody from continuing to disobey an order, and to continue to cause harm to themselves or someone else. You have to stop them by force.
And to put that using force on the person who is doing the wrong thing.
They're causing harm to the people who are trying to stop them, whether it's officers or other individuals.
Perfect. Thank you. And going off of that, using force is any act of force. Anything that is an act that is different than what the officer tells you and prevents them from effecting the arrest, that's enough force. It doesn't need to be some crazy display of, I don't even know, it doesn't have to be that crazy, it just has to be any act of force. Can everyone agree that we can understand what it means to use any act of force in preventing an officer from effecting arrest? Does everyone understand that definition? Any questions? All right. Now, we talked a little bit about beyond a reasonable doubt. And if you remember, that's what my burden of proof is to prove the defendant committed a crime beyond a reasonable doubt. And I'm gonna leave this up. I was hoping that y'all would be able to see it a little bit better, and I apologize, but it will be there if you need to reference or just refresh your memory as we move on. And if you have any questions, I know that it is hard to see, just raise your hand, don't be shy. If you need something clarified, that's what I'm here for. So we talked a little bit about beyond a reasonable doubt. Once again, I cannot give you a definition. There is not a definition. I wish there was, but there's not. That is up to y'all to figure out what that is defined to you. I can help you out a little bit though, and I want to use a little bit of an analogy to do so. So think of a puzzle. When you first pour the puzzle out of the box, have a bunch of pieces, can you tell what those pieces are going to be without referencing the picture on the box? Before you put it together, just pour it out on the table. There's just a pile of a bunch of little jigsaw puzzle pieces. Can you tell what that picture is going to be? No. All right. So that's kind of where we're at right now. You haven't heard any of the facts of the case, and you won't hear any of the facts of the case today. And the box that we're going to reference are these elements right here. And like I said, I wish you could see them a little bit better, but that's the box for the picture that we're going to reference. So right now, for the beginning of trial, we have a pile of some puzzle pieces, but we don't know exactly what it's going to be. This is what we're going to reference. So as you hear the evidence, I want you to listen closely, and the pieces of the puzzle will come together, and you'll be able to start to build that picture with just the puzzle pieces, and you won't need to reference the box. However, are you going to be able to see what that picture is going to be without having all the pieces? Once you get to it, you're putting it together, you're kind of seeing this is coming up with something. Will you be able to see that picture without all the puzzle pieces intact before you lay that last piece into the puzzle? You'll be able to kind of see the type of picture that it's going to be. And you can still see that as a whole without having every single piece in the puzzle. And this is what I believe that it means to be doubt. Does not mean there's zero doubt. There might be a few pieces missing. You're not going to get the whole picture because we don't live in a perfect world. We're not going to have the whole picture for you, but you'll be able to see the full picture even with a few pieces. I want you to keep this idea in mind. Keep that we're building a puzzle here. We're going to show you our side of the story. You're going to hear the evidence. And just remember that. So we're going to change gears a little bit. I'm going to get a little bit more interactive with y'all. Y'all have been great so far, so just bear with me. I'd like you to raise your hand if you've ever interacted with law enforcement. Any sort of capacity. All right, almost everybody. We see them on a day-to-day basis. They might be directing traffic, driving to work, like I said earlier, at the grocery store, next to you, at a restaurant. So everyone has seen officers in their capacity. We've already talked about, like you said, you listen to them when they're telling you to do something, or you stop and you clarify and figure out what they want to go on. All right. Raise your hand if you have any friends or family in law enforcement. All right, I'm gonna go down the list here. So we have Mr. Keys. Who do you know that's in law enforcement?
Church member.
A church member? And knowing that person, would that affect your ability to be fair and impartial in this case?
I don't think so.
All right. Mr. Beasley, did you say someone?
My brother-in-law is a former deputy, and my neighbor is a detective.
Okay. And would that affect your ability to be fair and impartial in this case, knowing them?
That's the son of.
Okay. Anybody else? Yes, Ms. Berry?
Combination, family members and I work inside of a correctional institution.
Okay, so you have a lot of interaction with law enforcement. All right, thank you. Mr. Fisher, you said someone as well?
I have a cousin.
Okay, and either one of y'all, would that affect your ability to be fair and impartial? All right, thank you for answering. So I'll keep hands over here. All right, Mr. Starr,
You just mean like police officers?
police officers, detectives, anybody in law enforcement,
Yeah, friends and family, but it wouldn't.
it wouldn't affect your ability. Thank you. Mr. Schaus, did I say it right this
yeah.
time? Okay.
Same friend, but
Okay. It wouldn't affect your ability to be fair and impartial. Mr. Bison?
Yeah, I have a cousin before he passed away, he was in LA, he was a detective.
Okay, and would that affect your ability to be fair and impartial in this case?
Him, but the experiences I've had with police, you know.
Okay. Thank you. If you want to elaborate privately later, we might call you back in to discuss those experiences if you don't mind. We won't, I'm not going to do it in front of everybody. We are on record and YouTube. Mr. Scott, did you say you said on the law?
Cousin. Yeah.
And that wouldn't affect your ability to be fair and impartial. Mr. Durio?
Just, neighbors and, family members of 911, just.
Okay. Would that affect your ability to be fair and impartial? Mr. Matthews? Did you- Friends and family, would it affect your ability? And then in the back row, we have Ms. Broussard. I think you already know what I'm gonna ask.
Ex-husband count.
As long as it's not gonna affect your ability to be fair and impartial. All right.
Just
Mr. Stuberfield?
super, yeah, it's friends and associates and, you know.
Okay. Anybody else? Ms. Silva? Leva, sorry.
Friends.
Okay, and it wouldn't affect your ability at all. Oh, Ms. Morris, I'm sorry, I missed you. Okay, and that wouldn't affect anything? All right. What about you, Mr. Miles?
Friend and a brother.
Okay, and that wouldn't affect your ability at all? All right. Thank you all for your participation and keeping things flowing. I like it. All right, so back to our case for resisting. What type of evidence would you like to receive if you're here and you get picked and you're sitting in that box over there? What type of evidence would you like to see in a resisting arrest case? Raise your hand or I'm gonna just. All right, Mr. Matthews on the end, what type of evidence would you like? Body cam footage, okay? Mr. Beasley?
If there's any physical evidence, or I was gonna say, yeah, video footage, some kind of physical evidence.
Okay. Anybody else, anything different? Mr.
Yep.
Star?
Definitely video, but also maybe multiple eyewitnesses.
Eyewitnesses, okay? That is a good segue into my next point. I was gonna ask, what type of witnesses would you like to see in this case? So we have body cam and we have possibly physical evidence. What type of witnesses would you want to hear from? In this case? We hear eyewitnesses,
Bystanders, people
bystanders,
not related to the arresting officers.
all right. Anybody else, anything different?
Incredible.
Credible. Y'all are helping me a lot because y'all are just going down my list of things I want to talk about and it's helping me get to the next point really quickly. So you mentioned credibility. Now, if a police officer takes the stand, should they get more or less or the same credibility as a lay witness? The same. That's correct. Everyone taking the stand, can everyone do that? Can everyone hold anyone that takes that witness stand to the same level of credibility? Yes? You look a little confused. Do you want to elaborate on that? No? Okay, thank you. So everyone gets the same level of credibility. It's up to you to hear the evidence and determine how much credibility you want to weigh that evidence after you've heard it. But right now, before you've heard from anybody on the stand, everyone gets the same level of credibility. Does that make sense? Is everyone able to do that? Yes? All right. Okay. We're talking about witnesses. Now, does anybody know what the one witness rule is? You can guess what it is based on the name of the rule. One witness? Yes. In the state of Texas, we can put one witness on the stand and prove our case. Now, I know that sometimes we'd like to hear from more people, we'd like to hear the whole story, but like I talked about earlier with the puzzle pieces, you can see the picture without having the entire puzzle together. Would you be able to be fair and impartial, coming to your decision if you only hear from one witness? Raise your hand if you'd be able to be fair and impartial, only hearing from one witness. All right, I lost a few people there. Mr. Fisher, why don't you raise your hand?
I mean, one is, I'd like to hear like, little more information just to make sure that the verdict that gives to that person, that we like one.
Okay, I understand that. You agree with him?
Well, I mean, is the one witness the arresting officer? Like a one-sided?
I can't go into the facts of the case, but I'm just gonna leave it at that. I can't go
Okay.
into the facts of the case. But given our burden of proof, our burden of proof is to meet the elements. Now, we can meet those elements by putting one person on the stand if they can testify to all of it. So would that change your mind if one person is able to testify to all of the elements that we're able to prove? Or that we have to prove, excuse me. Does that change your mind at all? And I know it's hard to go without going into the facts of the case. It's hard to know what you're going to see in the future if you are picked on this jury, but we just want to address that it is our burden to prove the case. It doesn't matter how many people we use to do so. And we just want to bring that to your thinking. Does anyone else have any feelings about the one witness rule that they want to share? Yes, Ms. Broussard?
They have to make sure that the one person is giving the correct information.
Yes.
And, I don't know if they still do lie detector tests, but, I don't know if they do that. I don't know if that's correct or not.
It's not something we're able to use in the court of law. They're not credible to the point of using in court, but they are fun, especially in crime shows. We don't do those in this actual court, unfortunately. So based on one witness, everyone okay with that? You know, it's a lot to ask of y'all, but I just want to make sure everyone's okay with us meeting our burden of proof. If it means laying out all the elements with one witness, is everyone okay with being able to do that? All right. Now, the next thing I want to talk about is the Fifth Amendment of the United States Constitution. Anyone know what the Fifth Amendment is? Mr. Stoma.
Oh, man, you-
Got a chance to talk. You know what the Fifth Amendment is?
I'm lost.
All right.
Can't do that.
Yes,
Or-
Mr.
It's the
Beasley?
right against self-incrimination.
Yes, so the right to remain silent. Everyone, as a citizen of this country, has the right to remain silent. That means that the defendant does not have to testify. And what that means for y'all is you cannot hold that against him. The right to remain silent means that you cannot take that silence and use it as an admission. Now, if the defendant chooses not to testify, the judge is going to instruct you that you cannot consider that evidence of guilt. And we talked about the burden of proof. Everyone remember we talked about the burden of proof? I gotta prove my case beyond a reasonable doubt. Puzzle, we all good there? The burden of proof is on the state. That's us at this table right here. Burden of proof is not over here. And it won't ever go over here. And that's why using a defendant's choice to testify or not to testify means you're shifting the burden, and the burden doesn't shift. So even if the defendant chooses not to testify, I don't know what they're planning on doing. I don't know if he's choosing or not, but I just want to let you all know that everyone has a right against self-incrimination. And that means everyone has a right to choose not to testify. And to choose not to testify means that cannot be held against them. Does anyone have any trouble with that? Make anyone? No? You good? All right. So if you get picked for this jury, can you promise that you will not hold the defendant's choice not to testify against him? And not weigh it as evidence in this case? Yes? Everybody good? All right. Now, we're gonna get a little personal. I'm almost done. You've all been great bearing with me, and I appreciate that. Now, after what I've told you today, and what you've heard from Judge Holmes, and you're gonna hear from the defense counsel in just a minute, does anyone have trouble sitting in judgment of another human being? Yes. Mr. Pfizer,
I don't know. Yeah.
you don't like to judge people? would you be able to sit in judgment of another if you were picked for this jury, or is it something that you cannot do?
I think be comfortable,
You would be comfortable?
but I think I could, not listen.
You'd listen. At the end of testimony, would you be able to come to a conclusion with your jurors, or would your personal beliefs prevent you from sitting in judgment of another?
I think I could come to a verdict.
You'd be able to come to a verdict, and you'd be able to put your personal beliefs aside and listen to the evidence that you've heard in this trial over the next few days?
I think
Thank you for answering that. Anybody else have trouble sitting in judgment of another? No, it's a little uncomfortable, it's not. Don't usually sit in a room and ask, all right, are you okay with judging people? Here we are. All right. Now that all of that's cleared up, before I sit down and give the podium over to the defense, does anybody have any questions for me? Anything that would clarify anything? Confused about something that I said, anything at all? You're welcome at this time. I want to open the floor to y'all. Anybody have any questions? No? All right. Thank y'all so much for your time. We really appreciate you being here. We wouldn't be able to do it without y'all. I look forward to presenting this case to you over the next.
Thank you, Attorney Gasper.
Thank you, Your Honor.
Attorney Wilkerson, the panel is yours.
Your Honor, and please the court.
Yes.
Good afternoon, ladies and gentlemen. I want to thank all of y'all for being here. As Ms. Gaspard said, without y'all being here, we would not be able to go through this process, which is guaranteed to us in our Constitution of the United States, as well as the state of Texas. Obviously, you're assembled here because the defendant has pled not guilty to the allegations of resisting arrest. I have the honor of representing the defendant in this case. Now, counsel made reference to a puzzle when talking about beyond reasonable doubt. So I'm going to give y'all just a little glimpse into how lawyers' minds work. All right, let's say you had to prove that Granny plowed the field with a green John Deere. Now, you've got a picture, and you've got Granny, you've got a field, you've got a tractor, it's even green, but the logo is missing. What do? How many of you would be comfortable saying, well, that's green, so I think it's a John Deere tractor? I mean, would you be able to say that beyond a reasonable doubt? And that is the question that y'all are going to be left with at the end of this case. Did the state reach its burden of proving this matter beyond reasonable doubt? Now, I'm also going to go over just a little bit about what these burdens of proof are. Sorry, I'll have some breathing problems. So if I pause for a moment and take a deep breath, it's because I'm starting to run out of air. All right. So you've got reasonable suspicion. Who knows what reasonable suspicion is? Yes, sir. Number
So
four.
the suspicion, that an officer would believe that something has happened.
All right. So basically, it is your very bottom level of evidentiary standard, right? So if you got a reasonable suspicion and you're a police officer, you can pull someone over or you can stop them on the sidewalk or the street, right? If you have a reasonable suspicion to believe an offense has taken place. Now, the next level, the next evidentiary standard is the next evidentiary standard is probable cause, right? And probable cause is the evidentiary standard necessary to bring a case. That probable cause exists to believe an offense has been committed. Interestingly, it's only one step up, right, from reasonable suspicion. It's what an officer needs to be able to arrest you. It's what's needed to secure a warrant. It's what's needed to charge a defendant. Probable cause to believe an offense has been created. Now, I noticed a lot of y'all have sat on civil juries. So you're probably familiar with the term preponderance of the evidence. And if not, if you haven't had that opportunity, or if you've never heard that representation or that evidentiary standard, I'll explain it to you here briefly. All it means, if you have preponderance of the evidence, is that something is 50.0001% more likely to have happened than not have happened, right? So note again, probable cause is below preponderance of the evidence, but preponderance of the evidence doesn't even close to approach beyond a reasonable doubt. Now, also, I know a lot of y'all have kids. Mr. Beasley, if the state were going to seek to terminate your parental rights based on some allegation that you abused your child, what do you believe the evidentiary standard would be in order to terminate that relationship?
What do I believe?
What do you believe that the state would have to prove in a child abuse case, right? With the CPS, there's allegations you have physically abused your child, and now CPS has removed that child from your home and is seeking to terminate your parental rights. So we're talking a little bit about evidentiary standards. What evidentiary standard do you believe it would require for the state to be able to say, no, not your kid anymore, you have no rights?
Hope it would be at least beyond reasonable doubt.
Ah, you would hope, wouldn't you? Except it's not. It's clear and convincing evidence. So after you get through preponderance of the evidence, you move up yet another standard to clear and convincing evidence. And that's the standard the state can terminate your parental rights. They prove by clear and convincing evidence that you physically abused your child, you haven't participated in the programs offered, so we're going to terminate your parental rights. Clear and convincing evidence doesn't meet the beyond a reasonable doubt bar that the state has to prove this obvious. The final step then on the rung is beyond a reasonable doubt. Now, admittedly, this is not beyond all doubt, right? I believe it was Mr. Scott, you had mentioned that if there not be a suspicion that some other something else committed the act, or how did you phrase that again, sir? With regard, we were talking, you were speaking with counsel about beyond a reasonable doubt and its definition. And I believe you had said something to the effect of that it would be that you have a reasonable belief, or that there's no other scenario that served as suspicion that someone else didn't commit the offense. I'm messing up the wording. Can you recall what you said? Okay. So, as the state's attorney has told you, we are here today for a case of resisting arrest. Now, again, a number of you have kids, so I'm going to pick on Miss Berry. Miss Berry, if a police officer approached your child, how would you expect your child to react to that?
The way I have instructed my kids is to stop, listen, see what's going on, if it's warranted, if it's merited, and 9 times out of 10, I'm gonna come in later and figure out what's going on to resolve and get to the bottom of it. But I have told them to like pretty much stop and listen to see what's going on. Don't disobey an order, or don't like escalate the situation.
So you mentioned disobeying orders. Should the first thing that an officer does after either identifying themselves or being in a clearly marked uniform. Other than identifying themselves, what's the first thing an officer should do?
Give the person instruction on what they expect from them or what they want them to do.
Give an instruction, right? And if no instruction is given, what do you presume?
Stop and wait.
So, Mr. Fisher, you have kids as well. Would you expect an officer to, how would you expect your child to react if that child was stopped by an officer, but not given any commands? Would you expect your child to be able to continue to walk on? Or would you expect that child to know to stop, for the officer?
I would, tell them in a respectful way what was the reason why they were stopped.
Okay, that's fair. You ask, right? Why are you stopping me? So we talked a little bit about evidentiary standard, right? Reasonable suspicion, and reasonable suspicion being what is needed to be able to temporarily detain someone, right, for further investigation of whether or not an offense has, in fact occurred. Now, I want to, so I'm going to kind of come off of that plateau and talk about some things that aren't so much part of this case, but counsel asked whether or not any of y'all knew any of us in this courtroom earlier. And Mr. Virio, I believe you intimated that you know Judge Holmes from other locations, correct? So, but a number of you also have friends and family in the police force or serving in some capacity of law enforcement, right? Does anybody know Officer Janice? Yes, ma'am. How do you?
Officer Janice,
Yes, yes, ma'am.
that's the in-law.
First initials DW.
Probably so. I know the first one should be D, but if that's Janice, that's the in-law.
And if that indeed is your in-law, and that in-law took the stand to testify, would you lend more credibility or less credibility to that testimony based on that?
I would remain impartial.
You would remain impartial? And so, and you believe you would have the capacity to do that 100%?
Yes.
Okay. Does anybody know a Officer Flanagan? Nobody? Yes, sir. Mr. Guerrero? How do you know him?
Just old friend of mine.
Okay.
Just some friends.
So, old acquaintance. Does knowing that officer, that knowledge, would that familiarity with that officer, cause you to judge that testimony in a more favorable or less favorable light? It would not affect your ability to assess credibility based on what's testified to in this case?
I'll be able to remain impartial.
Impartial, okay. How about an Officer Malone song? Nobody? Officer Murphy? No one? Officer Ballard? Yes, sir. How do you know, you are number 9, Mr. Shouse?
Yep.
How do you know Officer Ballard?
That's a friend of mine.
Friend of yours? And, with Mr. Ballard being a friend of yours, would that affect how you view the credibility of his testimony?
I don't think so.
And so, it's your assertion then that being friends with this officer, you would not judge his testimony any more credible or less credible?
No.
Based on, okay. And anyone else? Yes, sir.
He testified in a court case with my wife and her ex-husband.
And just for the record, you're number 12, Mr. Scott, correct? Testified in court case involving your wife and ex-husband
And her ex-husband.
and her ex-husband. Okay, and that familiarity, would that in any way impact your ability to be impartial when judging his credibility on the stand?
I don't particularly like it. If we're being honest.
No, I mean, look, that's, that's fair. That's a fair statement. Obviously, gentlemen right down, down the road from you as friends, right? So, I'm sure you all get along. But, okay, so let me ask you the same question though. You say you don't particularly like him. He says he's friends. He says that friendship is not going to interfere with his ability to assess credibility in this case. You not particularly liking Officer Ballard, is that going to interfere with your ability to assess credibility in this case?
I believe so because he wasn't very dispassionate on his testimony. Again, just being honest.
Well, and we appreciate that because without honesty, then we could end up with a juror who may not be able to follow their oath, and if we ended up in that position, especially in a case where we're not going to have 2 or 3 alternates, right? Then it would be a situation that would be bad for everyone, including the defendant in this case, right? So honesty and candor, is what we need during this process. I know it can be, put you on the spot a little bit, but thank you all, really. Finally, what does anybody know, Officer Guadi? Nobody? All right. So, I expect that one or possibly more of the people in that list may testify in this case. So I'd like to, while we're talking about people we may know, officers we know, friends and family, law officers or law enforcement personnel, I'd like to ask y'all, and I'm kind of go down one by one, and I know this puts you on the spot a little bit. This is not meant to judge you in any way, and I don't think anybody else in the room is going to judge you in any way based on your response, right? Over the past 6 years, has your impression of law enforcement grown more favorable, become less favorable, or there's been no change? Juror number 1, Ms. Moore, more favorable, less favorable, or no change? Juror number 2?
More favorable.
More favorable? And that's fair, right? Officers have a very difficult job. They put on that uniform every day and they go out there and they are on the streets and you never know what kind of situation they might end up, right? There's obviously over the past years been some tension in policing. In fact, probably all of you remember the George Floyd incident and how much tension that created in the law enforcement community at the time. A lot of officers left the field, other officers stayed, but that's kind of why I'm going down the road like this, just to kind of determine if the actions of other officers may have affect, or communities that in general may affect your view of officers at all. So juror number 3, Mr. Munez?
No change.
No change. Juror number 4?
That's a hard question to answer.
And
I
I,
don't particularly like the question.
well,
I have to answer it like,
yes, sir. I'm sorry.
Yeah.
More-
I think overall less favorable, but knowing with full respect to what you're saying, and the vast majority of law enforcement officers are good in what they do.
Unless,
And I wholeheartedly believe that, but in general, less favorable or things have come like 2 years.
and let's be real honest, I mean, even officers who may be quote unquote bad apples, they're still putting themselves in jeopardy, right? Now that's not to excuse that behavior by any means. I don't have to tell y'all what my views are, although I am a defense attorney, so you can take that however you think it might, however you think my particular views might go. Ms. Berry, more favor,
No change.
no change? Mr. Fisher,
Say no change.
no change? Mr. Sear,
Sorry, I would say, you know. I think there's a lot of good options, but I would say less favorable.
all right. Mr. Shaw, Stout,
No change.
no change? Mr. Visor,
Much less favorable.
less favorable?
Sense of paranoia if you have to interact.
Ms. Fogarty, more favorable? Mr. Scott,
Negating balance.
no change? And that's also very fair. Mr. Guria,
No change.
Mr. Matthew,
No change.
Mr. Mon,
No change.
I'm gonna butcher this.
Okay.
Ms. Veron Sosa,
Those are not,
Veron Sosa,
yes. Or those,
Zarza. Oh,
yeah, that's fine.
got it. Let me, all right, so more favorable, less favorable, or any change?
No change.
No change? Okay. Miss Sleva, please, you corrected it, okay,
No change.
no change, all right, Mr. Stoma,
I'm definitely more favorable.
more favorable? Miss Ned Broussard,
No change.
no change. Oops, I skipped something here. Did I skip any of y'all on this?
Number
Oh,
20.
well, yes, sir. Mr. Superfield.
No change.
No change? Okay. I'd like to talk about what it means to intentionally do something. How many people believe that you can do something intentionally if you're sleeping? Nobody would argue that, if you're sleepwalking or, in some frame of limited consciousness, you're still doing something, intentionally if it happens. If you drop a match in the trash can and did you intentionally set it on fire? Anybody? Nobody? What about if you are having a heart attack and you fall down and knock someone over? Did you assault that person? No? Number 19 and 20 both say no? Well, and why not? Let's stop for a minute. And why not? And go back to Mr. Stone. With regard to that scenario, did that person do it intentionally or unintentionally?
Had a heart attack and fell over. No. It wasn't intentional.
Well, let's, but the other elements of assault, right? There was contact. And we'll assume that it caused the other person who felt some pain, right? So if you're looking at elements of intentionally doing something, causing contact with another, and that contact being offensive or painful, right? Those would be elements of the offense of assault. So, if you lose an element, then the offense hasn't occurred, right? Would anybody disagree with that? Does everybody understand what I'm talking about now when I'm saying elements of an offense? And, the mens rea of intentionally, and mens rea is just a fancy way lawyers have of saying mental state or state of mind. Anybody confused at this point? Because I like to clear anything up if anybody is. So what are some reasons a person might not fully cooperate when initially coming into contact with a law enforcement officer? Ms. Morris?
It's situational, and maybe they didn't hear what the officer said.
And I would agree 100% that it's very situational, but I'm asking for some examples from y'all, if you can think of them. You just gave an example that perhaps that person didn't hear what the officer said. Juror number 2, Mr. Keys.
I don't know, it's not the person to me that I respect, it's the badge that he wears. And if he asks you to do something, you should honor him and do it as you've been instructed to do.
Okay, what is a reason that somebody might not? Can you think of
No
one?
honor, no respect.
Okay. Mr. Henry, can you think of a reason somebody, might not, comply with an officer? At least initially,
I would say past experiences,
past experiences, so if some type of trauma in the past had occurred, maybe, is that kind of what you're thinking?
yeah.
Juror number 4, Mr. Beasley.
Language barrier or misunderstanding of what was said.
Okay, I'm gonna skip a few of y'all down and go, Mr. Sire, sour, like sour apple,
Like car, but
car,
sour.
okay, I give up. Y'all beat me.
I don't know if it contradicted the law for some reason, I don't know. Or if it felt like it was putting the self or others in some type of harm, but
Jeopardy,
yeah.
maybe, just an example, I guess, of that, maybe, you're being pulled over on, an interstate and there's no shoulder.
Sure.
Then a person might proceed to the next exit, although I don't think that would not be resisting arrest if charged, that would be evading, but. Right, so anybody else have any other ideas on why somebody might not? Yes, ma'am. I apologize, Miss Ned Broussard.
Somebody might get pulled over by an officer, they may have had a bad day, and that might make them, not want to do. But, I've learned that I got pulled over and your attitude makes a big difference, because, if you don't comply, it's gonna make it bad. If you comply, make it good. Sometimes you might get a ticket, but sometimes you won't.
Understood. No, and so that's an important point, right? People are people. Yes, sir, Mr. Patterson.
What about the demeanor of the officer? He causes you to be afraid of,
Demeanor of the officer, so how the officer approaches you, you would say may affect how you respond to that officer, right?
Yeah.
Okay, anyone else before I kind of move on? All right. So what I was getting ready to go into, Ms. Broussard talked about, maybe having a bad day. Because people are people, right? And officers are people just like you and I, we all put our clothes on one leg at a time. Right? And we all have bad days where we're short with people. And then many of us have had great days where nobody could drag us down, no matter what they said or did. Would y'all agree in general with those statements? No? Okay. So, there were a couple of y'all who said, that you did not think that, having a friend in law enforcement would affect your ability to be impartial. Mr. Keys, you were one of those, correct? Now, you said that what you think it wouldn't affect your ability to be impartial. Right now you're under one oath to tell the truth, right? If you are picked for this jury, you will take another oath. And that oath will be to follow the law. And the law will be defined by this court at the close of the guilt and innocence phase of the trial. So, regarding that, if there's a response that you think something might not affect you, and there was another issue, someone else said something about think earlier, and I think I missed it. But if you think you might react in one way, certainly you're still leaving the door open that you might potentially react another way, correct? And so when you say, I don't think it would impact my ability, can you, sitting here now, say instead that it definitely will not impact my ability, or is there that chance?
Mr. Wilkins, you have 1 minute, unless you need more time.
Just a few more minutes, Your Honor.
Okay.
So I believe there was, also your number 4. I believe you also used the word think when responding to that question. And so my question to you, is very similar to the question I just asked Mr. Keys. Again, you're under one oath right now, and that's just to tell the truth. If selected for this jury, you'll be placed under another oath to follow the law. You said that you didn't think having, I believe it was it a sibling, cousin that was a former officer?
My brother-in-law.
Brother-in-law, okay.
Yes.
You said you didn't think it would impact you. Can you tell us now definitively that if you're selected to serve on this jury, it will not impact your ability to be impartial and follow the law?
That won't, I can follow the rules.
What's that?
It won't, I can follow the law.
All right, well, y'all have, heard my time get called, so I'm gonna leave y'all and, whatever group of you are sitting on this jury, after we go through and do what we need to do, forward to having the opportunity for you to evaluate this case on the merits rather than based on summarization or speculation. And at the end of the day, or the day of trial, at the end of trial, if I'm the defendant not guilty, thank you.
Okay, ladies and gentlemen, we're gonna ask that you follow the bailiff into the hallway, and we may call 1 or 2, or maybe some of you back into the courtroom with some follow-up questions. So at this time, the court will be in recess. Would you please stand as a jury, exit the courtroom? You can go through either one of the doors. Mr. High, if you want to leave, you can leave. You could have, I told you, you could have left when we started picking the jury.
He said they were.
The reset date, we're gonna give that to your attorney. I think she said it's gonna be December
9th, Your Honor.
9th. Okay, but stay in contact with your attorney and your boss.
Have a good day.
Same to you. Okay.
Do we have 18 months?